Greetings, everyone, and welcome to the PLUS webinar series. My name is Farai Mtero from the Institute for Poverty, Land and Agrarian Studies. I will be chairing today's session on understanding the proposed 18th Constitutional Amendment Bill and its possible implications for land reform. The webinar happens against the backdrop of the latest proposal to introduce the idea of state custodianship as an instrument that will ensure equitable access to land in South Africa. The process to amend sections 25 of the Constitution has been contentious, and it is not yet clear if the contending parties, mainly the EFF and the ANC, will find common ground. The webinar will unpack the meaning of the proposed changes to section 25 of the Constitution and discuss the implications for equitable land reform. So in our panel, we have Elmin du Plessis, a law professor based at the University of the Northwest. Professor du Plessis' work includes, she has worked on expropriation, constitutional and customary law. Also in our panel is Tsepo Fokane, who is a research and media officer for the Alliance for Rural Democracy. Tsepo's work largely focuses on social struggles for equitable land reform in South Africa. I would also like to introduce Edward Molopi, who is a research and advocacy officer at the Socio-Economic Rights Institute. Edward largely works on urban land inequalities in post-apartheid South Africa. So to kickstart our discussion, I'm going to start with you, Elmin. What do you make of the process to amend Section 25 of the Constitution? And how is this likely to unfold given the lack of consensus on the way forward? And is it not possible to expropriate land for land reform purposes under the current Constitution? Over to you, Elmin.
Great. Thank you very much, Farai, for the introduction and the invitation to this very important conversation. So as you have heard, my background is law, so my introductory talk at least will focus on the legal issues pertaining to the 18th Amendment. I want to start off by talking about the language of the Constitution. Our Constitution is written in very broad and plain language to make it durable and flexible. So there's a reason why a Constitution is written in plain language. And legislation and policy then are primarily contested in the political realm to give content to these broad and flexible language. Section 25 then provides such a framework where sections 25(1) to 3 protects existing right holders, not just owners, holders of all types of property rights, from arbitrary interference with the rights in property. And then sections 25(5) to 8 mandate the state to do land reform and to promulgate legislation to give effect to these rights in these sections. So as you can think, these two parts of section 25 is constantly in tension because to do land reform, existing rights might be encroached on. And section 25(3), the compensation part, seeks to balance between these rights by requiring that when there's expropriation, in this case, just an equitable compensation is paid and not market value as before 94. Another remark that I want to mention before we start to look at the amendment is that expropriation is a state power. So only the state can expropriate, and the state then becomes the owner of the property upon expropriation. So expropriation is merely a step in the process of doing land reform and not an end in itself. And lastly, the terminology of willing buyer, willing seller also deserves mentioning here. Willing buyer, willing seller as a policy was where government decided that it will buy land to redistribute for land reform purposes rather than expropriate. They've moved away from that now. And then if we speak about willing buyer, willing seller, when we speak about expropriation, it's a method to calculate market value. So neither of these two are contained in the Constitution. But to look now at each proposed amendment, and I hope you do have a copy of, or at least have read through the proposed amendment, because I'm not going to directly read from it. But if we look at the preamble, if we start at the preamble in the first paragraph, there seems to be some sort of suggestion that the slow pace of land reform is only viewed as problematic from the dispossessed, when this is actually a widely held view, confirmed in many court cases. So for me already it sets up this dichotomy that I don't think it's true in South Africa. I think most South Africans at least know that land reform must happen, although we differ on how that must happen. So I think setting up, creating the narrative there is problematic. Then the second paragraph there mimics what the committee was mandated to do, namely to amend Section 25 to make explicit what is implicit. But there seems to be little consensus on actually what is implicit in Section 25, and that's a question of interpretation. So on my interpretation, implicit in this section is that in any expropriation, an amount of compensation that is just and equitable is payable, and that's depends on the context. And then also then in some instances, that circumstances may indicate that the just and equitable amount of compensation is R0 or nil. So in our expropriation bill, they started listing instances where they think that can happen. And it's important because this position is notably different, and we will see this play out later, from expropriation without compensation, which in principle means that there's no obligation at all to compensate when property is expropriated. And then with expropriation without compensation, the expropriatee, so the person expropriated, cannot question the compensation because there's no duty to compensate. So there was quite an amount of discussion about this in the ad hoc committee, and the EFF's proposal, if you read that, states clearly without compensation. So this is the first deal breaker point between the EFF and the ANC. The EFF says without compensation, the ANC says nil compensation. Then the third paragraph, which I presume my colleagues will speak more to, speaks to the amendment addressing historical wrongs. And it says this amendment will ensure equitable access to land. And I think most of us here know that an amendment alone will not do that. We need legislation, we need policy, and we need implementation by strong workable institutions to bring about land reform. So if we go to the specific paragraphs that's amended now, so section 25(2)(b), I'm going to compare this with the previous draft, but we can maybe in the question and answer session speak a little bit more about this. But what is here is the express provision that nil compensation can be paid. Previously, in the first draft, it said only courts can do that. Now that's taken away. I agree with that approach. I think that the expropriator should have the authority to decide administratively that nil compensation is paid, and then it can follow a course set out in the expropriation bill to be promulgated. And if there's still disagreement, the courts are also an option at the end, and they can replace that decision. So I think that is the correct thing to do in that section. What they speak about here as well, just from a property law perspective, they say improvements, land and improvements. So that's for us still unclear, because the basic principle of property law say that everything that's permanently attached to the land forms part of the land. So section 25(3), which actually deals with the compensation itself. So 25(2)(b) creates the obligation to pay compensation. 25(3) says how that must be calculated. So not much has changed here. But I think what's important for me to mention just from a legal perspective is that the compensation standard remains just and equitable. So that's not taken away. And what is just and equitable is then, as I said before, a contextual question that will differ from case to case. And I think, in my opinion, this is where the bulk of the conversation should lie, because how do we calculate what is just and equitable? Justice and equity are often very difficult to quantify. So how are we going to have principles to tell us how we can determine that? And I've started developing a theory about the distinguishing between value and compensation that we can maybe also have a conversation about a bit later. Subsection 4A, I'm going to skip 3A because it doesn't say much. It just refers to the expropriation bill in Parliament. But things get interesting here at subsection 4A. So this is a new addition from the draft. And I can't remember from the meetings where this was actually discussed. So that's quite interesting. But the common heritage doctrine is often used in international law as a principle in the context of natural resources to say this is common heritage, it should not be commercialized, it has value for future generations, and then normally it's placed in some sort of custodianship. in our own legislation in South Africa, the Mineral and Petroleum Resources Development Act has something that states mineral and petroleum resources are the common heritage of all South Africa, so our minerals are common heritage, and then it says the state is the custodian thereof. So it seems like the idea of common heritage are usually linked to the idea of state custodianship. And I think that is presumably what the EFF wanted, because they stated quite clearly that they want an amendment in section 25.4 that says land is a natural resource and the common heritage which belong to the people as a whole under the custodianship of a democratic state. So it seems as if the ANC is there trying to find common ground with the EFF. But the EFF here just makes a clear link to common heritage. Amending section 25.5, I think this is where the custodianship, so this is where we're going to have quite a nice discussion today, I think. Section 25.5 orders the state to redistribute land. Despite this clear instruction, we currently don't have any redistribution act, and the policies that guide this is quite muddled and often inaccessible. So this is where a great problem lies in South African land reform. The EFF proposed that the state must take reasonable legislative and other measures which enable state custodianship and for citizens to gain access to land on an equitable basis, while the ANC proposal only refers to certain land, and that is the other heart of the deadlock. So that's the second place where they disagree. I'm almost done. I just want to go into a little bit about the custodianship issue. It's not new in South Africa. We have it in the Water Act, we have it in environmental law, and we actually had it of certain land, namely agricultural land. The draft Preservation and Development of Agricultural Land Framework Bill had it in, but that was removed in the final version that's now back in Parliament. So we can go into more detail about custodianship, but that basically means it's not nationalization. The state does not exploit the resource for their own benefit. It is where the state holds it, and in terms of quite comprehensive legislation, regulates it in terms of licenses and permits. So yes, that's my introduction.
Thank you very much, Elmaine, for those rich insights on the amendment. And now turning to you, Tsepko, as Elmaine says, that the amendment itself alone cannot deliver an equitable land reform. What are your thoughts on the constitutional amendment, and what could be the possible impacts of the proposed changes to the constitution on the rural poor? Tsepko.
Thank you so much, Farai. I think it's a very interesting time for us to have these types of debates in our country, because I think this is something that's been well documented and well explained all over the global south, and many scholars on the continent telling us that the national question is the land question. So when every liberation movement comes to this moment of saying, we believe we've been victorious, we've been triumphant, we're always going to turn back to land. It's part of our identity, belonging. So this proposal that's come is really interesting. We don't have to be politicians, but we begin to get an idea of what direction are the policymakers going in. Up to so far, Section 25 was always held as this rare, precious, perfect provision, that you can't touch property rights, you can't do anything different there. Any hint of expropriation must always be under what the old law said, which was not taking into account land reform at all. And many rural activists, have said they are in favor of an amendment that makes it clear-cut that there can be no compensation or no compensation whatsoever. And the reason and rationale is also something that our counterparts, Olamosa, Land Access Movement of South Africa, have put forward many, many times in terms of restitution. Will an amendment change the pace of land reform for us? We don't know, but we need to cut through some of the stumbling blocks that have held us back. What's been holding us back? White landowners inflating their property prices, like Prof. Duplessis mentioned, the willing buyer, willing seller, we weren't even there when these negotiations or provisions were made. And now we have such a rich debate happening because land is life in our country, and people are seeing that you don't have to just also hand over the decision making to law and policy makers when it doesn't reflect immediately what people on the ground want and need. People are land hungry. In fact, we were supporting some communities around the expropriation amendment bill hearings, and from different provinces, and they all had the same resounding demand, which is, let us amend Section 25. Let us not rely on the goodwill of people to interpret the Constitution broadly. We already had the most devastating reality for us. We watched the Mala Mala land claim. This is Mpumalanga. We also watched the Msiza labor tenant claim, where the landowners took the claimant and the department all the way to court over something as nebulous, as insignificant as it was not market value. So we need Section 25 to now speak to our realities. When it was first drafted, it probably had very good intentions and was going to do something, but without the necessary laws and the teeth there in the department and the muscle to say, this is how we're going to move the needle forward, many claims are just sitting stagnant. People are getting only parcels and portions of land claims restored to them under restitution because of exactly that. The disputes around the current land owners or the previous history of acquisition and the other factors that are already in our Constitution. Similarly, the labor tenant claims also at practically a standstill, although now we have the special master, which has brought in proposals and ideas, I think, that are progressive and are going to make sure that labor tenant claims are being properly adjudicated. But more importantly, we also have seen from the rural poor to say that if Section 25 is going to be amended, let it not be abused and misused, because already the reality of rural South Africa is that you're living on land that could be communal, you could be under a traditional authority or not. There's this idea from all over that these vast open areas serve no purpose, when in reality, people are already in very densely populated areas. There's disputes almost regularly about boundaries, neighbors, plots, residential sites, plowing fields, grazing land. So an amendment like this could actually do a lot of good, but it would need us to be sure that the department is going to put in place measures that will safeguard the info land rights holders. These are people who don't actually have formal title. And even though in our work it's the rural areas, I think it was Prof. Hall from PLAS who also highlighted once that it's like up to 60% of our country doesn't have formal title. So we don't want to see something like expropriation becoming used as this like political carrot. We're in an election year, we have eyes, we have ears. It's becoming popular and topical to speak about land, and parties that have taken one line may find themselves going in a completely different direction, understandably so, because they are now being aware that the public also are part of the debate and the discourse. Now, on the issue of custodianship, it is a big question mark of what exactly are we talking about. Under the minerals law, yes, the state is the custodian, but the state is the custodian of the mineral rights, but people continue to have surface rights. So are we not going to find ourselves creating a new category of conflict and unnecessary unrest because of already in mining communities, people who either purchase their land outright or are living on land that is mineral rich? We see that disputes are happening around who gets to benefit, who's the decision maker, who decides, who gets to have a voice, who's consulted. And you wonder a lot to say, this proposal that came out of the Constitutional Review Committee, it maybe is a good starting point, but it may not be the exact place we want to agree and settle on, because what is the custodianship of certain land? Prof has already given us ideas of what that means, but we get very nervous in rural South Africa when that happens, because we've constantly been othered. We've always been on the back foot. We've always been treated as though we are in certain areas. So we're going to get to be very much like scrutinizing what are the proposals coming forward, and are they going to address the land hunger, because there's massive land hunger. There's lots of, those misconceptions to say people in rural areas only want the land to do one thing, farm, and that's limiting. It's limiting. People have ideas of what are they going to do to unlock the rural economy, or how would they preserve their land, or what ways would they be working with customary law on how they want to see their land administered. So these proposals come at a very important time in our country, but equally we have to have a bit of, we must be a bit skeptical at times, because we've seen this before. We actually saw a very different expropriation amendment draft bill in the previous parliament. Now we are sitting with a new expropriation bill. At the same time, the Constitutional Review Committee is putting forward a very interesting proposal, but one that you can see it's a negotiation between political parties and members of that committee. So we want to make sure that our voices, the rural voices, are there. Our bottom line really is that we must safeguard existing rights in rural South Africa for people on communal land, people who are in traditional communities, people who've had beneficial occupation. I'm getting close to my conclusion, but it's really essential that we do not see ourselves getting swept away in the excitement of I think, rhetoric. And equally, we have to also stand up against alarmist language to say that the state is trying to now destroy all property rights, and that may not be what this proposal is bringing. It may actually be bringing us just a different angle, and it's for us to decide how do we want to actually address that. But I'll stop there. Thank you very much.
Thank you, Tsepo, for those important points. And coming to you, Edward, in the urban space, what do you think about the current amendments, the proposed amendments to Section 25 of the Constitution? Could this be a turning point for those struggling for access to land in the urban areas in South Africa? Edward.
Thanks, Farai, and thank you for the invitation to make inputs into this. I want to look at three things in answering what you've asked, Farai. So I want to consider first the use of expropriation as a method for land reform, and then secondly, I want to then consider. I think it's the willingness to expropriate. And then lastly, I'll then look at the initiation and activation of expropriation. And then I think other inputs I'll make in the question and answer session. So I'll just use this time to make those, to look at those three aspects. So, I mean, in the first one, looking at expropriation as a method for land reform, I think we do see expropriation as one of a range of tools that may help to widen access to land, to urban land for poor people. So it's one of the tools. It's not. I think it's what Elmine had said previously, that it's not the end in itself, but it is a tool that can be used to widen access to urban land. And then also it's. I mean, I think we do need to realize that there are people, partly based on the persistent patterns of apartheid, special injustice, and also just how the open market is set up, that there are vast majorities of people who are living in the inner city, particularly if you look at the inner city of Johannesburg, and informal settlements all across the country, who are just simply not going to be able to purchase land or access housing without any state intervention. So the way things are currently set up, if there's no state intervention, there are just going to be a number of people who are simply left out, and that's a huge problem. So if we look at this, we do see that state intervention is important in ensuring that poor South Africans are able to access affordable housing. Now, I think an important aspect here is that if expropriation is used, that it should be directed at securing tenure for poor people where they currently live. I think that's an important aspect too, that it should also be used as a measure to ensure that people are not relocated away, but that are able to benefit where they currently live. Now the primary use of expropriation, now this is whether it's with compensation or without compensation, right? Should first be used to ensure that it is a first step in securing people's tenure, right? So whether in informal settlements or in the inner city buildings that I've already mentioned in Johannesburg, that a lot of people there are unable to access housing and rental at the open market. So it needs to be used for that purpose. So yeah, I mean, I think that's the one point that I would like to put on the table. Because I mean, if expropriation is properly implemented, it firstly addresses the problem of insecurity of tenure, right? But then it can also be used to curtail the large amount of evictions that take place, litigation that takes place that results to evictions and people remaining homeless. So it's something that can assist in that process. Now I want to get into that second aspect about state actors being willing to expropriate, right? So if you look at it, you'll see that the state currently has the authority to expropriate, right, in the public interest. This authority exists under the Land Labor Tenants Act. It also exists under Section 9.3 of the Housing Code. And the problem here is that there has been an unwillingness, a political will to expropriate. Now, SERI has been involved in a number of cases. I'll mention one, and I might mention another one later if I see that my time still allows me. So there is a case in Marikana, which is in Philippi, Cape Town, where we represent in excess of 60,000 residents who live there. Now, this started off as an eviction case when we intervened, and one of the things that the residents were asking was that the state should expropriate that land for them. The state, which is the city of Cape Town in this case, also with support from the Western Cape provincial government, defended and argued against this. So they have basically been against the use of expropriation for the purposes of land reform. Now, fortunately, the courts did see in favor with the residents, and ultimately that's what essentially happened. So negotiations took place, and so negotiations are still taking place in relation to what that land can be sold for. So that's something that has taken place. And then the last part that I want to look at is the initiation and the activation of expropriation, right? So this tool, expropriation, has existed for quite some time. I mean, it existed pre-94, and it existed after 94. So with the Expropriation Act of 1975, it was there. And in both times, it's something that has been used by the state, particularly pre-94. The state did use it quite a lot to remove people from where they were, and to ensure that they use the tool for what they had intended to use it for. Now, post-94, the main barrier to expropriation in the public interest has really been a lack of political will in all three spheres of the government. So not only has government not initiated the expropriation for land reform, it has expressly actually opposed and even litigated against such these act times. I've already spoken about the Marikana informal settlements. The another one that I think time does allow me to speak about it, so let me just mention it quickly, is an informal settlement in eThekwini called Medlock Informal Settlement. Even there, we proposed expropriation of the land to evade eviction. And the municipality, even there, chose to rather relocate residents to some 45 kilometers away from the settlement where they are, rather than to use expropriation as a tool. Now, partly to answer the custodianship question indirectly, is that, you know, the state has demonstrated in the last 26 years that we cannot rely on them to expropriate in the public interest. And so what we advocate for is that there needs to be a provision that allows for people to initiate the expropriation process in the public interest. So this could involve the Minister of Public Works, that they could approach the Minister of Public Works to request that expropriation. So yeah, I mean, I think if in all we look at it, this is essentially a tool that can be used in the public interest, but then it has really largely not been used. And I think it's important that people are able to then initiate that process, because at the moment there is no provision for them to do so. Thank you.
Thank you, Edward, for those very important points on urban land issues and expropriation. Now to go back to some of the questions that could be explored a bit further. If expropriation is not an end in itself, and there are other policies, where should the focus be? What other policies should we be looking at to make sure that land reform benefits the poor? Maybe I could start with you, Elmin.
Sorry, that's a very important question, I think. So at the moment, what happens is you usually need, as Edward also alluded to, you need an authorizing act that authorizes the expropriation. So the Housing Act authorizes the state to expropriate land. The Restitution Act authorizes the state to expropriate land. The Labor Tenant Act authorizes the state. It's not really been used so far. Even if they started to say they're going to expropriate, they ended up negotiating, as Tsepo also referred to, and that often led to inflated prices. Because at an expropriation, the state does not have to negotiate for very long about the price. They must give reasons for what they think is just and equitable, but they don't have to go into negotiations as if when you buy land through contract. So we don't really have a comprehensive restitution framework at the moment. I think the high-level panel report also alluded to that. The presidential panel also alluded to that, where it gives the state the authority to expropriate land in order to redistribute the land and to say when that can happen. So I think that, for instance, would help us to know, okay, if the state wants to redistribute land, these are the requirements, but also very, very importantly, once they have expropriated the land, what will happen to the land then? Because that question is not, we're not really focusing on that question. And I think that was where I've heard a lot of frustration from Tsepo. We don't really, I was looking yesterday at a court case. People live on land and they don't really have substantive rights. For instance, farm dwellers, they don't really have substantive rights. They have rights against eviction. And we need to focus there on all these people that are so-called off-register people, how we can acknowledge the rights and how we can give substance to these rights so that it's not just something, so that they don't just have defensive rights when the state want to interfere or when somebody else want to interfere with the rights, but that they have rights that can be weighed up against, for instance, ownership. So I think that should rather be where the conversation is. I mean, expropriation is important. It is very, very important that we have a conversation about what we understand Section 25 to mean and what is unclear. I must say that I differ a little bit from Tsepo. I think it's not a constitutional amendment that should clarify that. I think it must be clarified in legislation, and I think the expropriation bill actually does that. So I think once the bill is promulgated, that sort of idea of what is compensation is a little bit more clear. So yes, I think devising legislation, redistribution, also pertaining to customary law land. We don't have a legislation for that. That, as you all know, was declared unconstitutional, and that's been a very slow process of securing those rights. I think that is where the focus should lie. And then we need to start to ask ourselves if, for instance, the right of somebody on customary land comes into competition with common law ownership, how are we going to resolve that conflict? Because at the moment, owner, registered rights, they are quite strong, but can we not restructure property law in South Africa in such a way that other rights in land are equally strong? And I think that is what we should move to.
Thank you, Elmaine, for those very important points. There's a question from Kanyiso Gumede. What are the plans to deal with properties that are attached to banks, as this has been raised as a problem that stands in the way of expropriation? Maybe Edward, you could reflect on that from an urban land perspective.
Thanks, Farai. So, I mean, if you look at it, right, it's quite broad in terms of what land, what's going to. I mean, I think what it acknowledges is that when we look at expropriation and property, we're not looking only at land, right? But that when we look at property, we are also looking at. It's quite broad. Even I think if you look at Section 25, it's quite broad what property there entails. It can actually even entail intellectual property. So in terms of the plans that are there to deal with properties that are attached to banks, so yeah, I mean, I do agree that we do need to look at this quite holistically and not only look at land that's being held by the state, but we also need to look at land, for example, that's being held speculatively. So it could be attached to the bank in that sense. That I think this is where I would make more inputs, is that if that land, for example, is held speculatively, so someone maybe has bought the land, whether through taken a bond on the land, and then is but holding that land speculatively, hoping that maybe at some day in the future that it will acquire more value than it does, then that particular piece of land can also be looked into to be expropriated. I think that there are provisions as to whether there's going to be nil compensation, or whether there's going to be compensation for that particular piece of property. But I do think that I would go so far as to say that if that property is held speculatively, and there might be other arrangements that we consider for that. But I think for me the key important thing is that particular piece of property should be one that people have got and have no use for it other than for speculative purposes, and then that we should consider that and see if we shouldn't expropriate that particular piece of property.
Thank you, Edward. Coming to you, Tsepo, given that we have seen instances where state custodianship has not translated to equitable access to land, especially for the poor, even in rural areas, what do you think could be done to ensure that expropriation proceeds in a manner that ultimately the poor can benefit, especially in the rural areas?
Thanks, Farai. I think the primary concern here is, let us first safeguard and acknowledge the existing rights, because before we would say we need to go and expropriate, there are so many people who are sitting with rights that are not formally recognized. And for as long as they're not recognized, then we will also get easily swayed to say expropriation could be the answer. Expropriation will not recognize the existing rights. That's our point of departure. Prof has touched on this just now. We do not have any framework that is going to govern people who are living on communal land, people who are holding land under customary law. And this is where we need to also first ask ourselves questions of, how do we protect up to 18 million people in former Bantustans and their existing property rights? Then once we have that clear in our mind of what changes do we need to make in law and policy, then we see that expropriation, in the case where you would have people who are coming into the rural areas to do these massive mega infrastructure projects, and they are doing them in such a way that they're taking advantage of this uncertainty in our country, where we've got the state as the owner of the land, but land is being administered by traditional authorities. We're being told that traditional authorities are the custodians of custom, and yet they are acting as though they are the owners of land. And in some areas, it's the land that people had purchased outright many, many years ago. So what we need to think about as well is that let us not be so easily swayed and say, will this change a lot for rural poor? It actually could, in the case, like I'm mentioning, of existing claims against the state for land rights. But more importantly, like we're all in agreement, we need more than just law reform right now. We actually also need to first remember that many millions of people are sitting without secure tenure. Those are the people who you need to prioritize and make sure that when we're going to introduce expropriation, it is in their best interest. It will be an expropriation whereby we've got sometimes these white elephant projects, big malls, old garages that are no longer working on land that used to be held by people under communal ownership, or it could be any other kind of project. Maybe the land can't be rehabilitated back to agricultural use, but surely we cannot also just have our rural countryside being littered with these mini city ideas of what is, development, what is infrastructure. And then we see people also still unable to make any use of those, improvements that were introduced in their areas. So first, let us safeguard the existing rights. Let us recognize them. Let us do exactly like Prof is saying, equate them as they already are to private ownership, so that when we think of expropriating, we don't say, oh, those ones are easy targets. They are soft targets because they don't have a title deed. They're sitting with a PTO. But even if you don't have one, your rights exist. They are real in law. But there's this confusion which was created and facilitated, I would say, by the state, by the department, and by the same political parties who are now bringing us custodianship as a proposal. They are the ones who gave into this idea that traditional leadership, we must bow down to such an extent that anytime people raise questions, even on the types of leaders they have, because it does impact how land is used and governed, that no, it means that they are lacking in culture. These same political parties were going and campaigning with the same traditional leaders. So the same political parties are using traditional leadership, and so are our other processes, around IDPs, always deferring back to traditional leaders and saying, once you've spoken with one individual, you've heard the voice of thousands. Let us first hear the voice of thousands, address the needs of those thousands who are sitting without recognized tenure that is not secure. And then we will see what expropriation can bring us over and above people with claims, people on farms, labor tenant claims, restitution claims. Thank you.
Tsepo, for those important points, very useful. I will now turn to you, Elmin, on the issue of compensation, just and equitable compensation. It features prominently in these discussions, and it appears that there's no clear approach to the issue of compensation. What are your thoughts on the best way to approach the issue of compensation in this process?
So I think a lot of the confusion came in still with the Expropriation Act of 75 being applicable. So I think it's really imperative that we pass the expropriation bill, and I think it's a good piece of legislation. It can be a little bit better, but I think it's good as it stands, because that sets out procedures. It makes it clear that the compensation standard is just and equitable. It's not market value, so nobody can be confused about this anymore, right? So the other problem is we've had some cases that touched on the idea of expropriation and compensation. Mala Mala could be seen as a case of compensation for expropriation, because the question there was how much is the land worth? Because if it's too expensive, it's not feasible to restore the land, right? And Mala Mala is this really great example of a total bugger up on calculating compensation. And I think we should start looking there, because you sit there. I think it was such a good case to go to the Constitutional Court. The state settled on the worst case scenario for them 2 weeks before the court. We didn't have time to air these issues in the court. We don't know why the state did that. There was a possibility, I mean, even the Land Claims Court with Judge Gildenhuys, which is an expert on expropriation law, but tended to lean more towards market value. Even he said he's willing to accept that, a possible price for expropriation in that case was, I think, 790 million rand. And yet the state paid 1.1 billion rand before we could go to the Constitutional Court, who would have given us guidance on how to calculate compensation. So I think, I'm not coming from a legal perspective, and I'm coming from a perspective that many of these issues need to be aired in court, because you only get to understand what something means once you can apply the law to the facts. That's part of getting meaning, right? Part of understanding what is just and equitable. Edward will know that we do that in eviction law. How do we know whether eviction is just and equitable? We had to do quite a few court cases to get to the point to understand what is a just and equitable eviction. And that's my sort of feeling that expropriation should go a similar route. But I know also court cases are very long and very expensive, and I don't know if we have that luxury. But that's where my thinking is going. The other case that Tsepo also mentioned, the Msiza case, I'm a little bit legally upset about the case, because in terms of expropriation, what happens is once all the legal requirements are met, on the date that all those requirements are met, that is the date of expropriation, right? So in terms of the Labour Tenants Act, once that Labour tenant met all the requirements in the Labour Tenant Act and the court says you are a Labour tenant, that is the moment of so-called judicial expropriation, which was not explored in full. And that is the point at which you pay compensation. So if you actually do the maths, they overcompensated because they calculated the compensation amount on the day of the court case, which was 12 years later. And in that time, the real owner, who was Mr. Msiza, did not benefit from the accrual of the value of the land. So I think there are many, many ways that one can use expropriation law. You can stay sort of true to the principles, but you can work with it creatively. And I think it is the task of lawyers to start to do that, to ask ourselves, what does it mean in certain situations to just and equitable compensation? Can you deduce the rate of, if you didn't pay your laborers well enough for 25 years, can you subtract that amount from the compensation? Can you say that the state has got, build roads and a lot of other infrastructure? I think that was the one big argument in Mala Mala. They dropped the fence between Mala Mala and the Kruger National Park. Can you say, well, that gave you a benefit from which you should not, financially benefit? So there are many, many interesting ways in compensation law that you can do this, but we get stuck to this idea that it's either, market value or no compensation. And I think probably we need to find a balance between those two where we can, do compensate. I think I can also maybe just deal with that idea of the banks. If I have I have a house, I've got a bond. My house is security for the bank for this bond. So if I don't pay the bond, the bank can sell my house in execution. If my house is taken away from me for zero compensation, I don't have a house anymore, but I still owe the money. So I'm going to have to be obliged to keep on paying off my bond even if I don't have a house anymore. And I doubt if many people in South Africa will do that. And once a lot of people stop doing that, then you have the collapse of the banks. I think that is one of the conversations that's being had there. So I think, it's about a balance and a fair balance, and that's going to require landowners to be happy with something that's not market value, and it's probably going to require the state to pay something, but we need to start talking about what is just and equitable.
Thank you, Elmin. There's also a question there. I think all of the panelists can respond to that question, where communities are actually in a position to identify land that they think is suitable for them, so that land may be expropriated. Is that a possibility? Is that something that can be done within the law and policy?
So I think Edward touched on that, and I think that's a very, very big frustration for us working in expropriation law. Only the state can expropriate. It's their prerogative. They can decide when they want to do it. So in that Fisher case that Edward was speaking to, they tried to force the state, and the court sort of said you have to come to some sort of agreement or come and tell us why you're not expropriating, which I think is a good start. I think in the expropriation bill comments, there were different versions, but on one version, I also suggested sort of a trigger clause, right? That says if communities have asked municipalities, for instance, to expropriate land over and over again, land that they fallow and nothing happens, then they should be able to be forced to expropriate the land. It's a little bit strange in expropriation law because it's a prerogative of the state, but I do think we need something similar, or at least to be able to go to court and for the court to say, you must come and explain why you're not expropriating, because the state is really not keen to expropriate, even for just and equitable compensation, and I'm not sure why. I don't know if they're waiting for the expropriation bill, but I think what Edward said there about the political will to expropriate, even with just and equal market value compensation, actually, for land reform purposes, that's just not there.
Edward, your thoughts?
Yeah, thanks, Farai. Yeah, I mean, it's exactly as Amin has said, and I've stated earlier, that it is the state's prerogative to expropriate. And so, I mean, I've listed two cases where communities have come forward and said, on this piece of land, we think that you need to expropriate, and this was done through the courts as part of the process of an eviction process that was taking place. As part of their defense, one of the mechanisms that they raised was that this is you can expropriate this particular piece of land that we are on. So yeah, I mean, I think communities are making that request. And also we have in our comments to one of the expropriation, the versions of the expropriation bills that have come. We've commented on both, and in the last iteration, we did put in this recommendation that communities must be able to activate this expropriation, and I think we've even outlined how we think that process can go about. And just briefly is that, you know, the community would firstly have, of course, identify that piece of land, and then make a request in writing to the Minister of Public, to the Minister in order to get that piece of land expropriated. So the Minister of Public Works and Infrastructure, that's the one that would be responsible for this. And then the minister, we in our recommendations, we think that then the minister must, within 180 days of commencement of this section, then give notice in the Government Gazette of particulars that are required in terms of the requests that are made, in which how this request must be delivered. And then, I mean, I don't want to get into a whole lot of detail about how that could take place, but so that to spare time. But I do think that it's something that it should be legislated, should be put in as part of the Expropriation Act in itself, and that people, then communities, are able to request this in writing to the minister, and that the minister must be accountable and also respond in writing, and decide whether they are going to expropriate or not, and give reasons if they decide not to expropriate that piece of land, and give what they looked at, what they accounted for, and why they won't be able to expropriate.
Thank you, Edward, for those insights. Tsepo, on your part, any possibilities for a community-driven process in relation to expropriation?
Absolutely. Absolutely. And this is what we want to see happening. There are so many people and claimants who are sitting with land claims that are stagnant, because it is now the Department of Agriculture, Land Reform and Rural Development that should be going to Public Works in order to now initiate the expropriation. And there's some kind of a reluctance between our government departments. I don't know if it's an issue of saying one department should not dictate to the other, but in reality, communities are already doing this informally. They are writing, they are petitioning, they are telling the Commission of Restitution of Land Rights, this is our land. What is the hold up? More importantly, in the case of land that communities will have earmarked, it's actually not implausible. In land claims already, the Commission is encouraging communities, when your land is not, when you can't be restored to that land, to identify, self-identify alternative land. So communities are doing this informal research on the ground, asking, driving around, finding out which farmers are just absentee, on their land. Or if they establish that in a district, a particular farmer's got 2, 3, 5 farms maybe, then you see that maybe a land ceiling was going to help. So this is happening maybe in the margins, but we want to actually see this formally recognized, because there are instances of communities compelling the Commission for Restitution to say, we have seen the land, we are insisting on this expropriation, putting pressure, even doing, before lockdown, doing these sit-ins at the office and saying, until you tell Public Works, go and fetch our farms for us. Because if not, we can't hope that officials will just do this. We can't hope for people to just think from their goodness. There is a massive need, and best of all, for people with already existing claims, it would be very strategic. It wouldn't be people who just want no one is looking for the house someone is living in. No one is fantasizing to expropriate that. We are talking about land that has got good agricultural production that is not being used, land that the municipality will have on its records, but is not also seemingly doing anything. So I think this is a massive, massive potential. Thank you, Farai.
Thanks, Tsepo. Colleagues, we have come to the end of our session, and before we close, any final words that you want to share? Maybe Elmin, Edward? If not, yes, Elmin?
Oh, no, I was not sure if Edward wants to go first. No, I just think we need more clarity on what the ANC means for state custodianship before we can really comment on that. So we have not really spoken about that, but the ANC at some stage, Honourable Member Traba said, it's in state custodianship the moment where the state buys the land before it gives it to the beneficiary. That's not state custodianship. And that we need clarity on that, and that it is already possible. So we need to ask, why are we asking for amendment for that? And I think those are the kind of, are we trying to move the attention away from the really difficult questions that Tsepo and Edward especially raised here, or are we actually trying to do something meaningful? And I think we should think about that. Thanks.
Thank you, Elmin. Edward?
Yeah, I mean, for me, it's let's just get to work, hey? I think that we've debated a lot of these issues for a long time. If the state is ready to implement expropriation, then let them proceed and do so. They're not being withheld from doing so. But yeah, they need to really do it, show political will, and then we know that they're ready to implement.
Thank you, Edward. So, colleagues, please allow me to end this session. And to our viewers, thank you for participating in this session and for your questions as well. And please check our websites, our social media page for information for the next webinar. Keep well. Thank you.
Thank you.
Thank you.